Good afternoon, everyone. It gives me great pleasure to welcome you very formally to our webinar on the review of the current matrimonial property legislation and its implications for religious laws in South Africa. So we are very privileged to have as our speakers two esteemed scholars of African legal pluralism. I'm going to introduce them, or rather condense their introduction, because if I should really go into detail on all their accomplishments, we'll probably have half of the time of the webinar devoted to that. So the first is Christa Rautenbach. She is a full professor of law and an advocate of the High Court of South Africa, with a career spanning over 45 years in academia and legal practice. So she served for 14 years as a public protector in the Department of Justice before she joined Northwest University, Potchefstroom campus. She specializes in legal pluralism, cultural diversity, and judicial comparatives. She has published or co-authored several leading books, including Introduction to Legal Pluralism in South Africa, and The Law of Succession in South Africa, Oxford University Press, and recently Reimagining Legal Pluralism in Africa, Balancing Indigenous, State, and Religious Laws. So Christa is an active member of editorial and advisory boards of several leading peer-reviewed law journals. Notably, she's the chief editor of Legal Pluralism and Critical Social Analysis, which is a top journal in her field. So we're very grateful that she agreed to join us today and to speak to us on on her experiences, rather, of matrimonial property laws and implications for religious marriages. Our second speaker is Professor Waheeda Amien. She's a full professor of legal pluralism, religious family laws, and human rights at the University of Cape Town. So she specializes in religious family laws and belongs to several bodies such as the South African Law Reform Commission's Advisory Committee on the review of aspects of matrimonial property law, the executive body of the International Commission on Legal Pluralism, steering committee of the International Network of Scholars Researching Unofficial Marriages, and the advisory board of the Dula Oma Institute. So she also serves on editorial boards of leading international journals, such as the Journal of Legal Pluralism and Critical Social Analysis. Recently, she was an acting judge of the North Gauteng Division of the High Court. So her work on the recognition and the regulation of Muslim marriages in South Africa have been cited extensively, including by the Constitutional Court. Waheeda has advised bodies such as the United Nations Expert on Minority Status, the South African Presidency, and the South African Commission on Gender Equality. So we're also grateful for her for coming to agreeing to speak to us today. I forgot to mention that Christa chairs the advisory committee of the South African Law Reform Commission, Project 144, which is on single marriage code. So these two speakers are coming from a wealth of practical and theoretical experience, and we look forward to their presentations and what they are going to tell us today. So once again, thank you very much and welcome to our session.
So thank you, everyone. Anthony, for that generous introduction. I'm going to switch off my video during the presentation so that we can just focus on the PowerPoint. It's a privilege for me to be part of this critical discussion on the review of matrimonial property legislation and its implications for religious laws in South Africa. Our presentation today is structured in two parts. My focus will be on the recognition of marriages in South Africa, with particular emphasis on the parallel legal reform processes led by the Department of Home Affairs and the South African Law Reform Commission over the last few years. Now, as the chair of the advisory committee for Project 144, I will provide insights into the Single Marriage Code initiative. Following my presentation, Waheeda, a fellow advisory committee member of Project 100E, Matrimonial Property Law, will present on divorce and matrimonial property law reforms, which is likely more relevant for today's discussion. Since my primary focus is on recognition rather than dissolution and property consequences, I will keep my remarks brief. Now, as you are aware, South Africa's marriage laws are currently fragmented, governed by multiple statutes, including the Marriage Act, which is administered by the Department of Home Affairs, the Recognition of Customary Marriages Act, which is administered both or jointly by the Department of Justice and the Department of Home Affairs, the Civil Union Act, which is administered by the Department of Home Affairs, and then we also have limited and piecemeal recognition of religious marriages through case law and legislative amendments. And then it's important to know that maintenance, matrimonial property and divorce legislation are administered by the Department of Justice. And this fragmentation between the Department of Home Affairs and Department of Justice is actually quite important when we talk about marriage laws in South Africa. Just looking at this patchwork of laws, which has created a legal maze that even legal professionals struggle to navigate. So imagine you being in love, ready to marry, only to find yourself entangled in a complex web of legal uncertainties. So it is this legal confusion that has prompted the push for a single coherent legal framework governing all marriages. So let me start with Project 144, which was initiated by the Law Reform Commission at the request of the Department of Home Affairs to develop a single marriage statute, one that would replace all existing marriage laws and create a unified legal framework. Now, this project has been an extensive multi-year process, starting in 2017 with key milestones that include a publication of issue paper 35 in 2019, requesting comments from the public. Then in 21, the release of discussion paper 152, which had a draft bill in it titled Protected Relationships Bill. And this sought to regulate all marriage-like relationships, also life partnerships. And then in June 22, the Law Reform Commission completed its report and it was approved for submission to the Minister of Home Affairs. In November 22, after presidency approval via the socio-economic impact assessment system, the report was sent to the Department of Justice for onward submission to the Minister of Home Affairs, because remember, the Law Reform Commission falls under the mandate of the Department of Justice. And then in August 23, the advisory committee informally shared the report with the Minister of Home Affairs, Minister Motsoaledi at that moment, aligning with the release of the 23 marriage bill for public comment. Now, this was meant to help integrate the Commission's recommendations into the legislative process when its report is not publicly available yet. Now, major challenges has emerged. In October 24, the advisory committee sought to submit the report directly to the parliamentary portfolio committee, overseeing public hearings on marriage reform. Now, as of 2025, it appears that the Ministers of Justice and Home Affairs have not engaged on the matter. The Ministry of Justice has not been briefed on the Commission's findings, and the Project 144 reports remain unpublished, leaving stakeholders in the dark about how their inputs were considered. Now, by June 2025, 3 years will have passed since the report's approval, but its status remains uncertain. So stakeholders have begun questioning, and we've received emails asking us whether their contributions to the Commission's consultations even mattered. If a report is completed but never released, what purpose did their engagement serve? Now, what was the key features of this protected relationship bill that the Commission proposed? It envisions a unitary legal system where all relationships, civil, customary, and religious, and also life partnerships are protected under a single legal framework. Now, key proposals included a unified system accommodating diverse marriage forms, the concept of protected relationships, which would include marriages and life partnerships, and then the elimination of religious bias, ensuring equal treatment of faith-based and cultural marriages, and then also the harmonization of legal requirements, including age of consent, capacity to marry, and marriage registration. Had this proposal been implemented, it could have provided a more inclusive and equitable legal framework for all types of marriage-like relationships. But with a lack of movement on the report, South Africa remains stuck in legal uncertainty. Now, as some of you may be aware, while the Law Reform Commission was conducting its investigation in Project 144, the Department of Home Affairs independently launched its own policy-driven legislative reform process, which ended up in the Marriage Bill. This happened 2 years after the Law Reform Commission began its work, creating a parallel track for marriage law reform. Now, recognizing the potential for overlap, we reached out to the Department of Home Affairs and engaged in several meetings and discussions with the department. We also participated in all ministerial dialogues except for the one involving Contralesa. Key milestones in the Department of Home Affairs process included in 21 the publication of the Green Paper, in 22 the release of the White Paper, in 23 the introduction of the marriage bill into Parliament, and then in 24 the bill lapsed, but it was revived again and it is currently subject to public hearings. And the most recent meeting was held in 18 February this year, ahead of the KwaZulu-Natal public hearings. Now, the Department of Home Affairs Marriage Bill aims to replace the fragmented legal framework with a single law governing all marriages, except, of course, life partnerships, and it ensures equal recognition of all marriage types, again, except life partnerships, and it introduced stronger measures against sham marriages and implements stricter registration requirements. It also addresses cross-border marriages, particularly those involving customary marriages with transnational elements, and it introduces mandatory premarital education and counseling, aiming to strengthen marriage stability. Now, while the bill represents, sorry about that. While the bill represents progress, its approach differs significantly from the Law Reform Commission's recommendations, particularly on the terminology protected relationships, the fact that we recognize unregistered relationships, and also the role of marriage officers and also the legal consequences of marriage forms, which we argue should in any way not fall under this marriage bill because that falls under the competency of the Department of Justice and Constitutional Development, which is also a key focus of Project 100E on matrimonial property law. So what is the position of Muslim marriages under the bill? And this could apply to any religious marriage. I just took Muslim marriages as an example because of our discussion today. So we all know historically Muslim marriages lacked full recognition under South African law, and the marriage bill now aims to correct this. It says any subsisting monogamous or polygamous marriage concluded before the commencement of this act, which marriage was not recognized under any law. So this means that Muslim marriages, both monogamous and polygamous, would now be recognized under South African law. And this aligns with the Women's Legal Trust versus President of Republic of South Africa, the 22 Constitutional Court case. So what are the requirements for recognition and compliance? Now, the bill sets out distinct requirements for monogamous and polygamous Muslim marriages. For monogamous, spouses should be 18 years and older, provide free and informed consent, and comply with religious customs. And polygamous marriages are all those requirements, and in addition, the husband must obtain written consent from his existing wives, and a court must approve the property regime before the marriage is valid. Now, these provisions reflect the effort to balance religious autonomy with constitutional rights, particularly in ensuring fair treatment of spouses in polygamous unions. So a key feature of the bill is its mandatory marriage registration requirement. Compulsory registration. Spouses must ensure that their marriage is registered with the department, and this places the burden of registration on the spouses rather than on religious authorities. So what are the deadlines for registration? For existing marriages, must be registered within 12 months after the Act takes effect, and the Minister may extend this deadline if necessary. And it, as we can see with the Recognition of Customary Marriages Act, it was actually done quite a few times. For new marriages, it must be registered within 14 days of solemnization. So what happens if the marriage is not registered? If a marriage is not registered, any interested party, for example, another spouse, a family member, a legal representative, may apply to have it registered later. And that marriage certificate is proof of the marriage, but lack of registration does not automatically invalidate the marriage. But failure to register can lead to significant legal complications, including difficulties to prove that the marriage exists, and also challenges enforcing spousal rights, which is, for example, property division. Now, a potential exclusion from legal protections is a real problem with non-registration. Now, marriage officers, Clause 8, religious leaders may apply to become official marriage officers, and no religious official can be forced to solemnize a marriage that conflicts with their religious beliefs. So what does it mean for Muslim marriages? Marriage officers may officiate Muslim marriages, but they are not legally required to do so. And this preserves, again, religious autonomy while allowing faith-based communities to integrate into the formal legal system. The proprietary consequences and dissolution, I will be quick because it is dealt with in the bill. Chapter 14, Clause 14, grants equal legal status to all spouses, ensuring Muslim women's rights are protected. Clause 15.5 allows spouses in existing unrecognized marriages to apply for a court order to change their matrimonial property regime. And Clause 16 requires all marriages to be dissolved under the Divorce Act. And this means that religious divorces will no longer be legally recognized unless they comply with South Africa's divorce law. Now, a key concern is the fact that the proprietary, oh my gosh, I always struggle with that pronunciation. The matrimonial consequences of marriages should not be dealt with in this bill. This falls under the domain of the Department of Justice, which is currently being investigated also by the Law Reform Commission, and Waheeda will elaborate more on that. So in conclusion, while the Department of Home Affairs Marriage Bill is a step forward, it raises several key concerns, particularly regarding religious marriages and legal consequences. Muslim marriages will finally be recognized, but registration is mandatory. Failure to register does not invalidate a marriage, but it can create serious legal complications. And the role of religious officials is voluntary, ensuring freedom of religion while integrating faith-based marriages into the legal framework. And with that, I will hand over to Waheeda, who will now discuss matrimonial property law and dissolution. Thank you.
Thank you, Christa. And from my side also, I would like to thank the Muslim Personal Law Unit and especially Mohammed Sangay and Najma Musa for inviting me to come and share some thoughts with you about the matrimonial property consequences of religious marriages, especially emanating from the Law Reform Commission process on reviewing aspects of matrimonial property law. So I'm also going to just share a presentation that I have, and then also just put my sorry, let me just put my video off. Can you see the presentation?
Yes, Prof, we can see it.
Okay, all right. All right. So, as I said, my presentation today will deal with the religious marriages aspect of our discussion paper. We have published an issue paper and a discussion paper for Project 100E on the review of aspects of matrimonial property law. And I will particularly talk about what our recommendations are for the matrimonial property regimes of religious marriages. But before I outline the recommendations, I think it's important to first provide a summary of the legal status of religious marriages in South Africa, which does to an extent overlap already with what Christa said, and to understand why it's important for the matrimonial property regimes of those marriages to be recognized and regulated by the state. Having said that, I also just want to put in a disclaimer in relation to Anthony's introduction of me. I wasn't cited by the Constitutional Court, but my arguments were used extensively by the Women's Legal Centre Trust in developing their arguments in the case. And so the argument that I put forward and that I've published on that Muslim marriages and religious marriages have to be recognized and regulated was then adopted by the court and incorporated as a court order. So not just recognition, but regulation as well. So I need to figure out how to move this.
Waheeda, if you just use page down, it should work.
Oh, okay, I've got it. Okay. All right. So, except for Muslim marriages, which were recognized as legal as recently as about 2 years ago through the Women's Legal Centre Trust case, no other religious marriage has been recognized as legal yet in South Africa. And this is the case despite our constitution making provision for the recognition of religious marriages. So if we look at section 15.3 of the constitution, the South African state is allowed to enact legislation to recognize religious and customary marriages or personal law systems, provided that such legislation is consistent with other rights such as gender equality. And so the project committee that Christa chairs is acting in accordance with section 15.3. And then section 31 also recognizes the right of persons belonging to religious and cultural communities to practice their religion or culture in association with other members of the communities and to form, join, and maintain religious and cultural associations within those communities. So again, these rights cannot be exercised in a manner that is inconsistent with other rights, including gender equality. Our courts have adopted a substantive form of equality, including a substantive form of gender equality. This means that the context of parties and their lived realities must be considered for equality to be applied. So in the context of marriage, it means that power relations between the spouses must be kept in mind, which recognizes that usually there are unequal power relations between husbands and wives, with husbands usually wielding the most power in marriages. It also means that the financial context of parties must be taken into account, where the reality is that husbands usually acquire greater estates with more assets than their wives. So in the case of religious marriages that are not legally recognized, the estates of the parties are treated as separate. There's no concept of a joint estate or joint sharing of assets for religious marriages. When something goes wrong in the marriage and a divorce happens or one of the spouses dies, it means that the wives in religious marriages are usually left financially vulnerable and without any legal recourse. And this was demonstrated, for example, in the case of Singh versus Ramprasad, which involved a Hindu husband and a Hindu wife who were married to each other by Hindu rights only. They did not have a civil marriage. Under Hindu law in South Africa, Hindus are not allowed to divorce each other. In the Singh case, the marriage did not work out, and the wife asked the Durban High Court to recognize her Hindu marriage as a civil marriage so that she could be granted a civil divorce. If that had happened, it would have allowed her estate and her husband's estate to be treated as a joint estate, and she would then have had a 50% claim to the joint estate. But the court decided not to recognize the marriage as a civil marriage, and the Hindu wife was then left financially impoverished. Then if we look at the Muslim marriage case of Ryland versus Idros, again we see the consequence of financial impoverishment being illustrated. In this case, the Cape High Court recognized a Muslim marriage as a contract and held that any proven terms and customs arising from the marriage contract could be legally enforced. One of the wife's claims was for an equitable distribution of her husband's estate, which was much greater than hers. But unfortunately, she couldn't provide evidence that the Western Cape Muslim community in which she and her husband resided followed a practice of equitable distribution of the spouse's estates at divorce or death, even though the wife provided evidence that such equitable distribution is allowed under Islamic law. Now, in the Hindu and Muslim cases that I just provided, none of the spouses were parties to a civil marriage. And so you may think, well, if they simply had a civil marriage, surely they wouldn't then have suffered these financial disadvantages. But the reality is that, firstly, it is not a common practice for parties, especially in Muslim marriages, to also enter civil marriages. And secondly, even if they have a civil marriage in addition to their religious marriage, it has been proven that wives are still more disadvantaged than their husbands. So, for example, in the Jewish marriage case of Ammar versus Ammar, even though the wife could obtain a civil marriage, and in fact did, she couldn't obtain a Jewish marriage because her husband refused to give her a get. And so this meant that she was an aguna, which is a woman who is chained in her marriage. Such a woman can't move on with her life, even though the husband could marry another woman under Jewish law. And the same reality also applies to Muslim and Hindu wives. Even if they have civil marriages, they are unable to marry anyone else if they are unable to obtain a religious divorce, while their husbands are able to enter religious marriages with other women due to the polygynous nature of Muslim, Jewish, and Hindu marriages. In 2022, in the case of Women's Legal Center Trust, the first of the religious marriages, namely Muslim marriages, received legal recognition, where the Constitutional Court found that the common law definition of marriage is unconstitutional because it excluded Muslim marriages. The court also found sections 7.3 and 9.1 of the Divorce Act to be unconstitutional because they did not extend to Muslim marriages. Section 7.3 of the Divorce Act allows the court to make a redistribution order for marriages out of community of property. And Section 9.1 of the Divorce Act makes provision for a forfeiture of assets for marriages in community of property. The court held that until legislation is enacted or amended to recognize and regulate the consequences of Muslim marriages, parties married by Muslim rights could institute a divorce action through the Divorce Act. The court further adopted the view that the matrimonial property regimes of Muslim marriages for the purpose of the Divorce Act would be treated as out of community of property. Recently, the Divorce Amendment Bill was adopted by Parliament. It purports to give effect to the Women's Legal Center Trust judgment by bringing Muslim marriages within the ambit of the Divorce Act. Another significant ruling was also made a couple of years ago in relation to all marriages that are out of community property without accrual. In the case of EB versus ER, the Constitutional Court held that all marriages out of community property without accrual are now covered by Section 7.3 of the Divorce Act. This means that regardless of when you were married, if you are married out of community property without accrual and your marriage ends in death or divorce, you may apply for a redistribution order, and the court may grant it if it is just and equitable to transfer assets from one spouse's estate to the others. But this only applies to parties who are in civil marriages, civil unions, customary marriages, and of course now Muslim marriages. If you are married by Jewish or Hindu rites or any other religious marriage, and you do not have a civil marriage, you would not be covered by Section 7.3 of the Divorce Act, which makes legal recognition of these marriages that much more important. So it should be clear from what I've said so far that great strides have been made in relation to Muslim marriages, even though it took the state almost 3 decades to get here, but still there is much more to do. In the Women's Legal Centre Trust case, the court ordered either the enactment of new legislation or the amendment of existing legislation to recognize and regulate the consequences of Muslim marriages. As Christa has already indicated, there are several processes underway to give effect to the court's judgment. I've already mentioned one, namely the passing of the Divorce Amendment Bill. The others include what Christa referred to as the Department of Home Affairs proposal for a marriage bill and the South African Law Reform Commission's recommendation for a single marriage statute. At the same time, the Law Reform Commission is also involved in reviewing aspects of matrimonial property law and has published a issue paper and discussion paper. In the process of our review, we have to give effect to the Constitutional Court judgment in the WLCT case, which includes the regulation of the matrimonial property regimes of Muslim marriages. But to not consider other religious marriages would be discriminatory and could potentially leave wives in those marriages without sufficient financial protection. So our proposals for the review of matrimonial property regimes extends to all marriages, including religious marriages. Traditionally, religious marriages incorporate the notion of separate estates, as I mentioned previously, but the adoption of joint estates or marriages out of community of property with accrual does not appear to have been rejected by spouses in Hindu and Jewish marriages. In the context of Muslim marriages, Islamic law recognizes the marriage as a contract between the husband and the wife. So essentially, parties can contract their marriage in whichever way they wish, including regulating their matrimonial property system in a manner that suits them. In the absence of a contract, the default position under the mainstream approach to Islamic law is that the estates of the parties are kept separate, but the parties can be compensated for their financial and non-financial contributions to the maintenance and increase of the other's estate. So, for example, if a husband is the main income earner and the wife stays at home to take care of the house and the family, Islamic law recognizes the wife's right to be compensated by her husband for unpaid labor in the home. Research reveals that several countries with significant Muslim populations that follow both the Sunni and Shia traditions allow their courts to consider financial and non-financial contributions to determine a just and equitable division of the matrimonial properties on dissolution of the marriages. These include countries like Malaysia, Singapore, Brunei, Indonesia, Morocco, Algeria, Afghanistan, Kazakhstan, Iran, the Maldives, Tunisia, and Turkey. In the case of Brunei, Malaysia, Singapore, and Indonesia, their default matrimonial property regimes are in fact joint, which recognizes the wife's non-financial contributions in the home. In Morocco, Algeria, and Tunisia, spouses can choose a matrimonial property regime where they share joint ownership of each other's assets. So in view of this research, we are of the view that any 3 of the South African matrimonial property systems, but particularly out of community of property with or without accrual, are consistent with Islamic principles governing the just and equitable distribution of matrimonial property. We received many diverse comments on our issue and discussion papers. Except that we didn't really get anything from the Jewish community, but from the Muslim community and the Hindu community and civil society, we received quite a number of comments. Respondents were asked to comment on a default regime for monogamous religious marriages and polygynous religious marriages. In the case of monogamous religious marriages, some said there should be no default regime. Many supported in community of property. Many supported out of community of property with accrual. Few were supported out of community of property without accrual. So it appears that the majority of respondents want contributions by one spouse to the maintenance or increase of the other spouse's estate to be compensated. That's the principle here. In the case of polygynous religious marriages, again, some said there should be no default regime, but most wanted a default regime that could be either in community of property or out of community of property with accrual, or out of community of property without accrual, subject to judicial discretion to compensate spouses for their contributions to the growth of the other's estate. Others said the same approach as in the Recognition of Customary Marriages Act should be adopted, which involves the husband applying to court for approval of the matrimonial property regime of the subsequent marriage. If the court approves the contract, the matrimonial property regime of the first customary marriage is then terminated and distributed according to which matrimonial property regime was entered into. If the first marriage was in community of property, the court would divide the joint estate between the parties, and then the parties would enter into separate estates for the subsequent marriages, regulating the property regimes of the two marriages. Again, it appears that the majority of respondents were in favor of contributions made by one spouse to the maintenance or increase of the other spouse to be compensated. In our discussion paper, with dealing with religious marriages, we make the following recommendations for monogamous and polygynous religious marriages. So in the case of monogamous religious marriages, we offer three options. The first option is that it should be out of community of property with accrual, unless the marriage contract excludes accrual or stipulates that it is a marriage in community of property. If no net value is stipulated for each or either of the spouse's estates, the net value is deemed to be null. But at the same time, we recommend that the court retain a judicial discretion to be able to make a redistribution order to ensure a just and equitable distribution of the estates. Option two, we say the regime should be out of community of property without accrual, unless the marriage contract includes accrual or stipulates that it is a marriage in community of property. And again, the court should retain a judicial discretion to be able to make a redistribution order to ensure a just and equitable distribution of the estates. And the third option is that it should be in community of property unless the marriage contract stipulates out of community of property with or without accrual. In this case, Islamic law would require an exclusion of the spouse's debts, because under Islamic law, the spouses can't be held liable for each other's debts. Again, we recommend that judicial discretion be retained to enable the court to make a redistribution order to ensure a just and equitable distribution of the estates depending on the circumstances of the case. Regardless which option is eventually adopted, it is important to keep in mind that parties always have the option to contract out of the default regime. In the case of polygynous religious marriages, we propose the following. The husband must apply to court to approve a written contract to regulate his future matrimonial property regimes. The court will terminate the existing matrimonial property regime and make an equitable distribution of the estates. The subsequent regimes are deemed to be out of community property without accrual, subject to judicial discretion to make a redistribution order that is just and equitable. If the husband does not obtain court approval for the written contract, the court must redistribute the estates equitably. If one of the wives becomes aware of the subsequent marriage, she can approach a court for an equitable distribution of the marital estate. We also make the following proposals where spouses are simultaneously in civil and religious marriages. Presently, if parties are in a religious marriage and a civil marriage, the consequences of the civil marriage apply. So we propose that if the marriages were entered prior to our proposed amendments coming into effect, the current status quo should apply, that the matrimonial property regime of a civil marriage should continue to apply. But if the marriages are entered into after our proposed amendments come into effect, we recommend that parties must have a choice to decide which marriage's matrimonial property regime applies. And in the absence of a choice being made by the parties, the court can apply the regime that renders the most equitable result. In conclusion, based on our research and the comments that we received from respondents on our issue and discussion papers, we are in the process of drafting our report, which we hope will we can submit to the Law Reform Commission during the course of this year still. Thank you.
On behalf of the MPLU, I'd like to thank our distinguished speakers, Professor Waheeda Amien and Professor Christa Rautenbach, for your insightful presentations here today. With time remaining in today's webinar, we now invite any questions or comments from our attendees. This is indeed your opportunity to engage with the speakers and delve deeper into the topic in itself. So if you do have any questions, please feel free to raise your hand. I will then request you to unmute yourself. Or should you have technical difficulties, you may type the questions into the chat box and I will pose the question myself onto the panel. Our team will ensure that we address as many questions as time allows. So I would like to now open up the floor to any questions from the audience, and we look forward to your thoughts and inquiries.
Mohammed, I'm reading a comment in the chat by Aslam Mayat, saying that the bills and proposals do not allow and empower a person to practice his or her faith, but requires the nikah marriage to be regulated in accordance with what the state determines their faith to be. The religious entanglement by the state may not accord with the constitutional provisions allowing you to practice your faith. There should be an opt-out clause which solves the problem of shoving the state's version of your religion on you. So I just want to respond to Aslam's comment, because I think it's reflecting a misunderstanding that a lot of people have about what both the single marriage statute, and Christa can talk more to that, but also what we are recommending through our proposals for the matrimonial property law and estates of the religious marriages. So we are not saying that we are going to dictate to religious communities how they must perform their religious ceremonies. So a nikah will still be entered into in the way that it is currently entered into, whichever way the community decides the nikah must be entered into. The formalities and the rituals and the customs of the nikah will still follow the same formularies, the same customs, the same rituals that are presently being performed within communities. So our proposals don't impact on that at all. What we are saying is, if you enter into a nikah, however you wish to perform the nikah, we are recommending that there must be a default regime, and we are considering 3 options for the default regime to regulate the matrimonial property consequences. The first option, as I said, is out of community property with accrual. So in a case like that, if the parties enter into a nikah and they don't have an antenuptial contract, then the default with accrual will apply, and the commencement values will deemed to be null. If they want to have an out of community property with no accrual, then they must enter into an antenuptial contract that explicitly excludes the accrual. So a nikah, as I said in my presentation, is a contract between the 2 parties. And one of the terms of the contract is how they decide to regulate the matrimonial property estate or the matrimonial property consequences. Currently, if you enter a nikah, then the default is with out of community property with no accrual, right? What we are saying is that's one of the options we are considering. The other option that we are considering is that it will be out of community property with accrual. But if the parties don't want that to apply, then they must have a written contract that excludes the accrual. So there is an opt-out clause The opt-out clause is if you don't want the default to apply, then you must enter into a written contract that excludes the accrual. Or if you want accrual to apply, but you want to be able to say my estate is valued so much, then your written contract must indicate a commencement value. So I hope that that clears up the misunderstanding around that. And if it's still not clear, please raise it again. So Aslam says, my question relates to the consequences of the marriage and not the formalities of how the ceremony is performed. And I hope that my response there has covered that as well, that we are in fact considering 3 default regimes for the matrimonial property consequences, and that there is an opt-out clause. So if parties don't want the default to apply, they can then enter into a written contract that explicitly excludes accrual and keeps it out of the community of property. I do also want to say at the same time, we have been considering, I mean, we've taken into consideration the constitutional obligations of the state, the constitutional obligations that we must abide by in making our proposals, and that we are governed by substantive equality in this country. So we have to consider the position of the parties and the unequal power balances that operate within marriages, and that in most instances, the husbands acquire the greater estate, the wives don't, because of the circumstances of the marriage. When the marriages end, there's an unjust and inequitable situation that arises where women tend to walk away being financially destitute. That is inconsistent with Islamic principles. There has to be a consideration of the contributions of both parties to the marriage. And if a wife is contributing by way of unpaid labor, that has to be compensated for. The accrual system takes into account those contributions by way of a formula that allows the parties to be able, they come in with their separate estates, they manage separate estates during the marriage. There is no intermingling of the estates with an accrual system. It is at the end of the marriage, when the parties, either there's a death by one of the parties or there's a divorce that happens, that a calculation of, well, what have the parties contributed to this marriage? And so they need to be compensated for their contributions. And there's an automatic formula that applies that takes into account that contribution. So that is in accordance and in adherence with Islamic principles of contributions to the marriage being compensated for, whether they're made by the husband or by the wife.
Thank you, Prof. Amien, for that excellent response. I don't know if Christa has a few words to say on that matter.
Yes, I would like to add something, and the one is one that I'm actually concerned about, and that's requirements, because it seems that the bill of the Department of Home Affairs currently in Parliament is suggesting in clause 5 that you have these general requirements for a marriage, 18 years and older, consent and of sound mind, but then it adds in clause 2, for a marriage entered into in accordance with custom or religion to be valid, it must, in addition to these 3 requirements. So immediately the proposal of the Department of Home Affairs suggests that there are different requirements for marriages and religious marriages, because then it must be negotiated and entered into or celebrated in accordance with the respective custom or religion. So that is similar to the definition in the Recognition of Customary Marriages Act, where it implies that a customary marriage must be celebrated in accordance with the custom of that community. And the problem that creates is that we are going back to the question whether those customs were followed or not. And the moment you bring in religion, it comes back to this question of religious dogma, and that you should not involve yourself in religious dogma. So immediately the courts are going to be required to evaluate those customs or religions to see if they were followed or not. And then we get in that dangerous situation of getting entangled in religious questions. So that's one clause in the bill of the Department of Home Affairs that really concerns me. Number one, because it doesn't treat marriages equally, because it requires additional requirements in the case of customary and religious marriages. And I'm not so sure that that is a good idea. The other thing that I wanted to say is the consequences, and I agree here with what Waheeda is saying, because the consequences can be regulated. The state is not telling you in the legislation or the proposed legislation how you should regulate the matrimonial consequences. It gives you options, and you can decide how you want to put that in the nikah, how you are going to regulate it. It actually just requires parties, Muslim parties who want to get married, to think carefully about the consequences. We must remember that the Constitution is a wall-to-wall one. You cannot say that certain religions and customs are excluded from the operation of the Constitution. We cannot get away with that. And I would think that nobody is telling you how to do it, but gives you options. And if you do not want to follow that options, you can opt out, as you say it, by regulating that in your nikah. Thank you.
Thank you, Prof, for that excellent response. I would like to now jump to the participants. I see there's two hands raised. Firstly, Dr. Fatima Isop, if you can unmute yourself and you can ask the question.
Thank you so much, and thank you to both Professor Rautenbach and Professor Amien. This question could be to either of them. I mean, I actually have three questions. The first one is, what is your understanding after the 22 WLCA judgment and the recent Home Affairs directive saying you can register and get a marriage certificate? What do you understand the matrimonial property regime to be now of people who have been married by Muslim rights only, as in by nikah only? The second one is the issue around matrimonial property regimes, and I agree with you, Waheeda, that I think the default system is should be out of community with accrual. But what does that mean, for instance, the duty of support? And in South African law, both spouses have a duty of support, while in Islamic law, it's only the husband's responsibility to support his wife and kids. How will that fit into the new system? And then lastly, in terms of divorce, you're saying that divorce will only be accepted if it goes through the Divorce Act. What does that mean for, will women still have to get the talaq and the fasakh, or is it, how's that actually going to work? So either of you can answer those questions. Thanks.
Christa, are you okay with me going first?
Yes, you can go ahead. I think you know more about consequences than I do anyway.
Okay. So thank you very much, Fatima, for those questions. Those are very, very good questions that you've raised. The first question is a very short answer to that. Your question was which matrimonial property regime applies now for Muslim marriages? And according to the Constitutional Court in the Women's Legal Center Trust case, it would be out of community property with no accrual. So, and because parties can now institute divorce actions through the Divorce Act, when that happens, the courts will treat the marriage as out of community property with no accrual unless the parties had entered into a written contract that regulated the matrimonial property regime in a different way. Your second question relating to the duty of support, also a good question. This is a consequence of the marriage and would need to be regulated through the Maintenance Act. So, there would need to be a review of the Maintenance Act and the legal obligations relating to the Maintenance Act. Because as you know, currently under secular law, the obligations are reciprocal. Under Islamic law, the traditional approach is that the husband has the unilateral obligation to maintain the wife. And I think a very complex discussion would need to be had around the relationship between nafaka, maintenance, and the matrimonial property regime. Because the nafaka as it stands, with the husband having a unilateral obligation to maintain the wife, almost coincides with the estates being kept separate. And so, yeah, I think we would, we would need to have another conversation about what the nafaka would need to look like in a situation of if the default regime were to change. But presently, we have no guidance from the courts, except actually we do have guidance from the courts. The Ryland versus Edras case, and in fact the Khan case, looking at polygynous marriages, have recognized the Islamic law obligation of a husband to unilaterally maintain his wife. So that duty is recognized under our law. And we would need to have a conversation about whether that duty needs to be incorporated into the Maintenance Act as is. Then thirdly, your question about the divorce, currently you can institute a civil action for divorce through the Divorce Act if you are have obtained talaq, or you are undergoing a Muslim divorce either through a khul or mubara'ah or fasakh. What does that mean for the religious divorce? Now, this is one of the gaps in the law at the moment, is that even though you might obtain a civil divorce, that doesn't necessarily mean that the religious divorce is recognized under law. The religious divorce has not been incorporated into the Divorce Act. You still would need to obtain a religious divorce in the ways that it is available at the moment, either as in the form of a fasakh through the imam, or through by talaq from the husband, or if the wife is effecting a khul. So that has not been incorporated into civil legislation. And Christa can talk to this, but my understanding of the single marriage statute is that it doesn't recognize religious divorce. That's my understanding. You would get a civil divorce, but you still wouldn't get a religious divorce. That you can't get a religious divorce in terms of the single marriage statute, or the proposals that we are making to the matrimonial property law consequences through a secular court. You would still need to obtain it within the community in the way in which it is currently available. So that at the moment is still, in my view, a gap that's missing, that we haven't actually attended to in terms of secular law. Yeah.
So if I can add to that, it's true that the marriage bill, that is, if I speak about marriage bill, it means it's Department of Home Affairs. In clause 16 says a marriage can be dissolved by the death of one of the spouses, or by a court of decree of divorce as contemplated in the Divorce Act. So it means it is a civil divorce, and the religious divorce, whether it is a get in terms of Jewish law or if it is the talaq in terms of Muslim law, will be a religious divorce, and that would not have the same effect as a civil divorce. That would be state institute, but the other one is in the private sphere of a particular religious community. So it would typically mean that in the community that party or that a couple will not be regarded as divorced, and that can have some social implications in that private sphere. But in the public sphere, they will be regarded as divorced because they did it in terms of the Divorce Act. which is also a complicated situation, I think, because I think sometimes that the danger of divorce in a religious sphere means that it can be used in that power situation that Waheeda was referring to. So it can be used as a threat by a husband saying, listen, I'm not going to give you a religious divorce. We've had many cases, especially in the Jewish community, with the get. And that is also the reason of Section 5A in the Divorce Act is to ensure steps that the court can take to sort of bully a party into giving that religious divorce, especially if it is detrimental to the position of the other spouse. So, of course, we're going to get those dynamics where you have two divorces, the religious one and the civil one, but it is one that we have to manage as we go along, I think. Thank you.
Thank you, Prof, for that eloquent answer. I'm sure Dr. Fatima received all the answers that she was looking for. Unfortunately, due to time constraints, we cannot entertain many more questions, but I will just like to open the floor just to see if there is one hand that's still raised by Faisal Bulbulia. And then there is
Mohammed,
one comment that's made.
Mohammed, there's also a question in the chat that I think
Yes,
needs to be
yes,
addressed, and that's the question about same-sex marriages, because I think
yes,
there's some misnomers around that as well.
yes,
So
correct.
recognition of religious marriages in terms of the single marriage statute. I can't remember what the marriage bill says about this, but again, would religious officers are allowed to register marriages according to their own conscience and their own religious practices and their religious beliefs. So a religious person, an imam or a rabbi or a Hindu pandit who who does not believe that same-sex marriages adheres to their religious convictions would not be required to perform a same-sex marriage. Yes, same-sex marriages are recognized under our law. You can enter a same-sex marriage and register it through the Civil Union Act. A religious officer, if they believe that they are not permitted by their religion to perform same-sex marriages, would not be required to do so.
Thank you, Prof. Amien, for addressing that question from Jamie Samuels. Last thing, due to time constraints, as I mentioned earlier, we can only afford to give the floor to one more question from Faisal Bulbulia, whose hand was up for quite some time. So if I can request you just unmute your mic and then you may ask your question to the panel.
Hello, I'm Faisal Bulbulia. I'm a practicing attorney. I wish to commend Christa and Waheeda for their presentations. I'm having a problem with the marriage bill. The marriage bill says that all existing marriages, monogamous and polygamous, will be retrospectively recognized. Now, and then it provides for those people who have existing marriages to apply for registration. Now, if you take the example from the Customary Marriage Act, and if you took the statistics of people, it's a very low percentage that actually went and then registered their existing marriages. Secondly, the problems that are going to arise from the proprietary consequences of those marriages, I don't know whether it's well thought of. Many couples will be married without any contract pre-existing. They just married by nikah. Will they be deemed to be married in community of property? Because there'll be no contract. So I think it will lead to many more problems by having the act apply retrospectively. Thank you.
Okay, shall I start with registration? We, at the Commission, we were actually split on whether registration should be a requirement or a validity requirement or not. And we also use this argument of just look at registration under the Recognition of Customary Marriages Act. It's very slow. In the beginning, when the act was just enacted and came into operation, there were a lot of registrations. And then it started to trickle down. And now a lot of the court cases deals with the question whether there was a valid marriage or not. And this always happened when there was, for example, a dissolution of the marriage through death or divorce of one of the spouses. So it is a huge problem. And we do not always agree in the Commission about what the answer is. I follow, and I mean, the proposals of the Commission, and I gather now that what the Department of Home Affairs put in the bill is that they do require registration, but if it does not happen, or if it did not happen, it would not influence the validity. It would be much a more difficult thing to prove the existence of the marriage, but it is possible. My feeling is that registration should actually be a requirement, because it just gives so much more legal certainty, and then leave the option that if it was not registered, maybe we can do something about that. I know it's not a popular viewpoint, but I think I'm a little bit more of a black letter lawyer, and I think it's because I was in practice for so long. Just trying to prove the existence of something is much more difficult than just requiring, listen, everybody must register. It's going to take us quite a number of years, but I mean, people can eventually know, listen, if I want my marriage to be recognized, I should register it. So it is one of the problem areas, I think. With regard to the matrimonial consequences, I will hand over to Waheeda.
Thanks, Christa. Yeah, I mean, we've taken the approach that whatever amendments or proposals we make regarding changes to matrimonial property law of marriages, including religious marriages, cannot be retrospective. And in the context of religious marriages, it makes sense because you would basically be infringing on the religious freedom of people who've already entered into their marriages. And they entered into their marriages with the view that the matrimonial property, the marital estates would be regulated in a particular way. So we can't be making proposals that will affect those marriages. So whatever proposals we are making would be prospective, it would be going forward to regarding new marriages. It means that existing marriages, Muslim marriages, for example, would still be treated as out of community property with no accrual unless the parties decide they want to change the regime. And then the Matrimonial Property Act currently does have that option in terms of Section 21, where you can apply for a change of the matrimonial property regime.
Thank you, Prof, for that excellent response. I'm sure there are many other questions that the members wish to ask and the attendees wish to ask, but unfortunately, due to time constraints, we have to conclude today's webinar. So as we come to the close of today's enlightening webinar, I would like to firstly extend my sincere thanks to all for your thoughtful questions and active participation. On behalf of the Muslim Personal Law Unit at UWC MPLU, we would like to express our deepest gratitude to our esteemed speakers, Professors Waheeda Amien and Professor Christa Rautenbach, for the insightful discussion on the topic of the review of the current matrimonial property legislation, implication for religious laws in South Africa, a very relevant topic in our current day and age indeed. Professor Rautenbach's comprehensive overview of the processes involved, particularly in her role as the head of this project, has given us a valuable perspective on the dedication and hard work put into this endeavor by all members of this commission, and we are truly grateful for her significant contribution. Similarly, Professor Amin's elaboration on the comments received on the issue paper and her recommendations regarding the recognition of religious marriages has provided us all with a deeper understanding of the subject matter. We thereafter also wish to acknowledge and thank all the key individuals who played a crucial role in making today's event a success. Our heartfelt thanks goes to the Dean of the Faculty of Law at UWC, Professor Jacques de Waal. Thereafter, the HOD, Head of Department of Private Law, Professor Sumari Viljoen, for their continuous support of the MPLU. We also extend our appreciation to Professor Anthony Diala, Head of CLEAR, the Center for Legal Integration in Africa, for his unwavering support and for opening today's webinar so eloquently. Special thanks is also due to our technical team at the DOI, Dalla Umar Institute at UWC, particularly Ms. Kay Sapto, for ensuring the seamless technical execution and effective promotion of this event. Lastly, we thank all the members of the MPLU, the Muslim Personal Law Unit at UWC, for their efforts in organizing today's successful webinar. In conclusion, we would like to express our sincere thanks and appreciation to all attendees once again for your participation and engagement. And we hope you found the discussions valuable and thought-provoking. And I would like to just make an announcement that the recording of today's event will indeed be shared with all registrants in the days to come and on the UWC Faculty of Law's YouTube channel. So please stay tuned for the exciting events the MPLU has planned for the remainder of 2025. And we look forward to seeing you all at our future events. Have a lovely day further to one and all.
Thank you, Mohammed. Much appreciated. And thank you for everybody for attending.
Thank you all from my side too, and for your comments and your questions. They assist us in going forward with our work. So thank you very much, everybody.